Kako. This is Poka Lainui, and you are listening to KWI 1080 on your AM dial. This is Hawaiian Potpourri, where we discuss a potpourri of ideas from Hawaii, looking at local issues as well as looking across the Pacific at other lands and making comments, or at least I'm making comments. If you would like to call and share your opinion on my comments or on other comments, our telephone number here is 524-1080. This is an interactive discussion in which we raise these many different issues. It's a potpourri of ideas, of topics, and you are invited to join in and share your opinions on these various matters. Over the next 2 hours, we'll have an opportunity to take a look at, beginning with some of the local issues, and from that local issue we'll expand to issues happening in America as well as issues occurring in the rest of the world. And just as I do have an agenda in terms of some of the matters that I will be discussing, it is not a closed agenda, and I welcome your thoughts on these subjects. And if there's something really bothering you, and you find an opportunity to introduce that subject into this discussion, give me a call. Telephone number 524-1080. You know, there's an agency newly created within the state government, and that agency is known as the Public Land Development Corporation. I haven't really discussed that matter before you for two reasons. One, I wasn't all that familiar with this particular subject. Didn't pay very much attention as it winded its way, its creation through the state legislature. And I've been trying to keep an eye on the topic itself, but I certainly cannot claim to be an expert on the matter. And I don't know if there are any experts at this time, because it's a newly created organization. It's an organization, it seems to me, created to cut through the red tape, cut through the bureaucracy, and to be able to deal with Hawaii lands rather than having to go through regulations, protective procedures, and to more quickly move along decisions so that the state will be able to use its resources for development purposes, to generate income, to follow the public policy that is being taken by a current administration. Like many other issues, there are always positive attributes as well as negative attributes to a single question or a single topic. And while we hear about the positive attributes, that what we really need is a public land development corporation that is able to carry out very quickly and effectively the wishes of the governor's office or the appointing authority to those who sit on this public authority. On the other hand, one could say that these rules and regulations, these bureaucracy that have been created, have not necessarily been created for the purpose of stopping actions from taking place, but they have also been created, or perhaps more primarily, for the purpose of protecting certain specific interests that should not be simply marginalized or set aside. For example, issues such as the protection of the environment. So while others may demean those who want to protect the environment, calling them by various names such as tree huggers, others are saying, but this has been the policy undertaken by these policymakers, whether they are legislators or congressional folks or whatever they are, or however they were created, or maybe even within administrative organizations or agencies. but they were taken for specific purposes. And just because someone is frustrated about having to go through those steps does not mean that you create now a whole new regime that calls for greater, quote, efficiency, which runs over values that have been taken to protect the Aina, to protect the ancestors found in our environment, such as the birds and the bees and the flowers and the trees and the skies and the seas. So there are a variety of ways of seeing a particular issue. Another issue is, of course, the burials and the sacredness of the burials. To what extent should they be protected? To what extent should they be set aside and not protected? Or in the protection, they can still be removed. Well, a procedure had been started to take a very considerate, methodical approach in addressing these issues. Not to make one decision that, well, whatever it is, we need to have economic development, and so we need to set everything aside. Nor should one say, I guess, irrespective of what the reasons for a development is, we must always leave the bones in place and never move the bones. I think both extremes of such arguments are inappropriate. And the thing is, we don't have enough people listening to one and another. Now, this PLDC, or this Public Land Development Corporation, having been created out of the state legislature, and some would say without appropriate hearings or just passed by sort of in the middle of the night when people weren't fully informed, and others would say, well, it wasn't really in the middle of the night. We gave the regular public notice that all other bills had been given. But still, people are saying, well, we really were not called attention to the impact of this body that can go through all of the state's assets and make a determination as to whether or not they will develop this or develop that, and not paying attention to the the specialized circumstance of each of these lands. Some people say, well, what are you talking about, specialized circumstance? Land is land. There's no such thing as specialized circumstance. I remember meeting with a friend of mine, Roman Bidor, who comes from the island of Palau. He's an attorney there, and we had worked on issues of self-determination. And essentially, he had been working for the independence of Palau. And of course, I had been associated with the independence struggles both in Hawaii and in other places, especially in my role in my involvement with indigenous peoples of the world. And Roman had told me once about the specialness and the peculiarities of land in Palau, in that just as human beings are given names, each specific parcel is given a name. And so they were not known as meets and bounds, and then you have starting at this corner, then you measure according to certain directions, the length, and then you change direction in another length. No, they were given specific names, and the names carried with it a character of that particular land. And so that was the specialness of these lands that was historically invested. Here in Hawaii, we have had names of these special lands, but as we went through the process of, some would call it modernization, others could call it cultural and historical amnesia, we began to lose these names. Very fortunately, we have a process within Hawaii, and I think it's at the county level, by which the naming of different developments, the naming of streets, the naming of what else? Place names. They tend to go back in and look at the historical significance and older names. And so as you look at street names, for example, they try to get or retain some of the older names. So I like that about what the city and county has been doing. But it goes to underline the idea that all of the lands, there's specialness is in all of these lands. And what has happened is in the burial council, what they have done is developed a procedure by which you recognize the importance of the EV, of the bones, the burials. And so you have a very methodical procedure in order to avoid the desecration of the bones, but not saying necessarily that you can never touch or move the bones. Okay, so certain procedures have been established. Now this PLDC, the Public Land Development Corporation, comes around with certain rights to essentially break through a lot of these things. But the rules for the PDLC has not yet been developed, and so they are going through the process of developing these rules. The chairperson of the PLDC, I understand, is Calbert Young. And so a petition has been written to Calbert Young saying that as you develop these rules for the staff and for your administration, as you draft these rules, this petition is saying we want the following to be clearly incorporated within the rules. I'm not going to read all 21 recommendations, but I think you will get the drift by the first 5, and then over a period of time, or as a program continues on, we can go through other requirements. The first is prohibit any sale or gift of public lands. Now that's a huge statement. In other words, you cannot sell off, gift, or alienate, we would use in the legal concept, to separate the land from the, at least the quote, current owner. In this case, I say owner, which includes the state of Hawaii as the trustee for these public lands, including the stolen lands, or what others call the ceded lands, whether or not you really accept secession or cession of these lands to the United States. That will depend on what term you choose to use. But these are lands that had been under the title of the Hawaiian nation, or under the title of the Crown lands, or the Crown, the ali'i, the government, not merely the ali'i, but the governing head of state, to support the head of state. Now, what had happened back in 1893, after these folks, the puppet government created by the United States, took over, they eventually claimed all of the lands of the government and of the crown, all of the waters, and as well as all of the people, and said, we are ceding these lands and people and all of our assets over to the United States. So this is what they ended up calling ceded lands. From the Hawaiian perspective, these are stolen lands, lands which was never their own and never appropriately theirs to hand over to the U.S. government. And since the handing over to the U.S. government, the United States government then parceled out a portion of those lands and gave it to the territory and to the state of Hawaii. But they still carried the ceded dressing or ceded taint to these lands, so they're still called ceded lands. So what this first petition is that you prohibit any sale or gift of public lands. So when they talk about public lands, they're talking about the ceded lands, and they're talking about the purchase lands. You see, in this idea of ceded lands, what it says is all the lands stolen and given, and then transferred from the federal government to the territory or to the state of Hawaii. These are what we normally call the ceded lands, but there were some lands that were subsequently traded. So these stolen lands were exchanged for other lands, or they may have been lands that were actually purchased by the state government or by the territory government, and it came into the general coffers of the state. The state has not been able to differentiate or separate in their inventory of these lands what was, quote, ceded and what was purchased lands. So the more practical approach being taken is, let's include all of these lands as ceded land, because 90% or even perhaps a larger percentage of the lands that came into the state were ceded lands. And because we have no way of dividing the lands between ceded and purchased, let's call it all ceded lands. Another argument can be made was that any monies used to purchase additional lands was probably used as a result of, or created as a result of, these stolen lands. So that's how some people are looking at that. Anyway, that's the first petition. Prohibit any sale or gift of public lands. The second requirement is that PLDC projects do not interfere with Native Hawaiian traditional and customary practices or any historic or cultural properties. Now, well, what is this Native Hawaiian traditional and customary practices? It's sort of like a right of Native Hawaiians to go on to undeveloped lands for purposes of collecting firewood or wood itself, very important, for purposes of collecting tea leaves, for purposes of accessing these lands in order to maintain a traditional and religious practices. Now, if you look far enough back into English tradition, you have the Magna Carta. The Magna Carta dealing with civil and political rights of people. But along with the Magna Carta was a second Magna Carta, which was the Magna Carta of the woods. The right of the people to access the forest, access the woods in the forest, access to collect from the right to hunt in these woods, part of a second Magna Carta, just as important as the one that we are more familiar with, which protects the right of habeas corpus, the right of free speech, and all of those things. The rights of kings as well as the rights of commoners, the Magna Carta. Okay, so in Hawaii we had this second Magna Carta sort of incorporated in the protections of, as the lands were divided in what was called the Mahele, some people call it the Great Mahele. As the lands were developed or separated, so that we moved it from one held in trust by the ali'i, or by the, it was called the, now I've forgotten the name, not the Kuhina Nui, the head of state, and it was a new term that was developed when Paia Kamehameha created the unified government. And so as one separated the rights of these lands from the ali'i nui, which is not the appropriate term, and started parceling it out to private ownership, it was still reserving the rights of the Native Hawaiians, or of the Kama'aina or the Ho'aina, to access these lands. So that right continues in Hawaii, so that you had a number of court cases, the Kalipi case, the the Pele Defense Fund case, and a number of other cases in which the Hawaii Supreme Court continued to say that those traditional rights continue, are maintained. So in this second requirement, that the PLDC projects do not interfere with Native Hawaiian traditional and customary practices or any historic or cultural properties. So they're still protecting the historic properties, the cultural properties, and this, of course, would include the iwi, or the bones of the people. And not only that, but the funerary, I think they call it, items, those related to burials and funerals that are sacred to the people. The third, they require early consultation and collaboration with groups whose culture, traditions, practices, or historic resources may be adversely impacted. So the requirement of consultation, a very important aspect of maintaining some control over the PLDC. When you talk about consultation and collaboration, you find a lot of that language also found in the United Nations Declaration on the Rights of Indigenous Peoples, and in the the International Labor Organization's Rights of Indigenous Peoples. It says when you're dealing with indigenous lands, indigenous territories, indigenous things, you must consult with the indigenous people. And the consultation must be true consultation, informed consultation. Not just call a meeting and say, okay, we've consulted and we just move ahead. No, you need to be very serious and ingrained in that idea of appropriate, informed consultation. The next requirement, require and document that projects have access to a long-term source of reliable water to support the project needs when applicable. Recognize that projects need to secure water services that meets applicable rules and regulations, either by having received an approved water allocation from the State Commission on Water Resource Management, or through municipal or private systems, and comply with all county water department regulations and requirements for development of water facilities infrastructure. Oftentimes we don't give, I guess, water enough consideration. You just turn the tap on. You want water, turn the tap on. Doesn't always work that way, especially, for example, in Waianae, where you have a lot of the farmers saying we need more water, we need larger pipes, we need meters to be able to maintain a stronger water flow. And they have been told year after year after year, sorry, not enough water, so you're just going to have to deal with that. And yet, on the other hand, when they decide to develop Ko'olina resorts, suddenly there's enough water for the resort, although you're creating essentially a second Waikiki. Now, where did all the water suddenly sprout up from? Oh, there's a lot of water. We can use the water. You see, the excuse is these waters are not potable or not drinkable, but because we can use it for our golf courses, it's still okay for golf courses and for, agricultural purposes. So they got away with that excuse. And it's correct. They have been using non-potable water for their agriculture. But what the heck? If you had non-potable water, why not use it for the other agricultural use out in the Waianae area? Anyway, they're making an issue, those who are promoting this petition, making an issue. Yes, we want to make an issue of water use. Anytime you develop, you have to be sure that you have enough water so that you're not going to take it from the residents already established in that area. Very good. There's 21 such recommendations. I won't go through all of them, at least not right now. But the people who have signed this, or whose names are listed here, I didn't find their signature itself. They are Kat Brady, she's a coordinator with Community Alliance on Prisons. Kamana'opono Crab, he is the Kapohana, the Chief Executive Officer of the Office of Hawaiian Affairs. Lynette Cruz, Dr. Lynette Cruz, who's also President of Kalei Mailiali'i Hawaiian Civic Club. Henry Curtis, who's the Executive Director of the Life of the Land. The Honorable Representative Faye Hanohano, representing District 4, that's on the Big Island. Hinale Moana Wong Kalu, Chair of the Oahu Island Burial Council. Eric Gill, the Financial Secretary and Treasurer of the Unite Here, that's Local 5. Hale Guansen, Dr. Guansen is Executive Director of Pacific Justice and Reconciliation Center, and Kahu Kaleo Patterson, Dr. Patterson, Community Roundtable Facilitator. I guess he's a Community Roundtable Facilitator of this PLDC. In other words, he works, it seems, within the PLDC and is using that position to open up the process and allow and joining in fact, on this petition. This is Poka Lainu. You are listening to Hawaiian Potpourri.
Kaulana na pua o Hawaii Kupa ama hope o ka aina Iki mai ka elele o ka loko ino Pala pala anunu me ka paka Pane mai Hawaii moku o ke ave Koku ana honoa o Pilani Ka ko o mai ka